Good afternoon, everyone. My name is Mike Cicero, and I'm an IP attorney with the law firm of Taylor English Duma here in Atlanta. As chair of the Trade Secrets Committee of the Georgia Bar IP section, and in the spirit of the rapidly approaching Thanksgiving Day, I would like to thank each and every one of you for attending today's webinar entitled Year 5 of the Defend Trade Secrets Act, the Bench and Bar Weigh In. Now, this will be 1.5 hours worth of CLE credit, and the Georgia Bar will be handling issuing that credit to all of the attendees of today's program who have registered for that credit. So that will be handled at their end, and there's nothing further that you need to do. And speaking of our committee, I would also like to thank our Vice Chair, Neil Weinrich, for all of his work in helping to organize today's program. And I would especially like to thank all of our panelists, whom Neil will introduce to you later in his role as moderator. And we appreciate all of the panelists' time and effort spent in preparing their presentations, as well as their time in being here today. And today's webinar covers just one of many current issues involving trade secrets law. And for those who are interested in joining our committee to continue to bring these programs to you, we're going to be circulating some contact information at the very end as a Zoom message, so that you can use that contact information, get in touch with one of us to join our committee, and we would certainly love to have you. Now, May 11th of this year marked the 5th anniversary of the Defend Trade Secrets Act, and this webinar is going to cover the origins of that act, the main differences between this federal act and the various states' laws, and the most significant developments of the act that occurred in the very first 5 years of its existence. And this agenda slide gives all of you a bird's eye view of what's going to be covered. And generally, we're going to be hearing first from our panelists, and we're going to get remarks from His Honor. And then after that, there will be a 10 to 15 minute question and answer session. If you do have a question, feel free to type it using the Zoom Q&A feature, and our panelists will do their best to address it during that session. Now, to say that we have an esteemed assembly of panelists today would be an understatement. As I mentioned, the person who will be introducing each of them to you is our moderator, Neil Weinrich. Neil is a shareholder at Berman, Fink, Van Horn, PC here in Atlanta. He concentrates his practice on commercial litigation involving restrictive covenants, trade secrets, computer fraud, and other competition-related issues. He represents employers and employees from a wide variety of industries and unfair competition disputes in courts in Georgia and in other jurisdictions, and also in arbitral forums. Recognized by super lawyers as a rising star in Georgia since 2012, he writes and speaks frequently on various issues that arise in competition-related cases. He is also the co-founder and regular contributor to Georgia Non-Compete and Trade Secret News. Neil currently serves as the vice chair of our Trade Secrets Committee, as I mentioned, and he also serves as the vice chair of the Labor and Employment Committee of the Atlanta Bar Association. Neil served as on the drafting committee on the covenants not to compete for the Uniform Law Commission. In the past, Neil served as vice chair of the Digital Forensics Subcommittee of the Trade Secrets Committee of the American Intellectual Property Law Association. He also served as co-chair of the Ethics and Professionalism Committee of the Young Lawyers Division of the Georgia Bar. Neil graduated from Tulane University in 2003 and from the Emory University School of Law in 2006. And with that, I will turn it over to our moderator, Neil Weinrich, for the introductions.
Thanks, Mike. I appreciate the introduction. And I'm, as a trade secrets practitioner, very excited about today's program. And I'm particularly excited because we have a truly excellent, outstanding panel that I have the pleasure of introducing. Our first panelist is James Pooley. And for those of you who don't know Jim, Jim is truly a godfather of trade secret law in the United States. Jim's practice focuses on trade secret law and management as an advocate, advisor, a testifying expert, and a neutral. Jim tried his first trade secrets case in 1974, that was 7 years before I was born, and he's been practicing trade secret law since, so he's truly an expert. He's an author or co-author of several major intellectual property works, including his treatise called Trade Secrets and the Patent Case Management Judicial Guide. His most recent business book is Secrets: Managing Information Assets in the Age of Cyber Espionage. The Senate Judiciary Committee relied on Jim for expert testimony and advice regarding the passage of the DTSA, which I'm sure we're going to get insight into his experience testifying during his presentation. From 2009 to 2014, Jim served as the Deputy Director General of the World Intellectual Property Organization in Geneva, where he managed the international patent system. Jim is a past president of the American Intellectual Property Law Association and chairman of the National Inventors Hall of Fame. Jim currently serves as chair of the Sedona Conference Working Group 12 on Trade Secrets. And in 2016, Jim was inducted into the IP Hall of Fame for his contributions to intellectual property law and practice. So Jim, thanks for joining. We're truly lucky to have you here today. We've also got my partner and mentor, Benjamin Fink. Ben is a shareholder with me at Berman Fink Van Horn here in Atlanta. Ben's practice focuses on business and commercial litigation with a heavy emphasis on competition-related disputes, including non-competes and trade secrets. Ben is a published author on restrictive covenants, and he also blogs and co-hosts podcasts on non-compete and other trade secret topics. And you can find his blog and podcast through our website. Ben is a frequent guest speaker at seminars on competition-related topics throughout Georgia and other parts of the country. In recognition of Ben's thought leadership in the trade secrets arena, he was invited to attend the inaugural Sedona Conference on developing best practices for trade secrets issues. And today he serves on the drafting team for the Sedona Conference's Principles and Best Practices Commentary on Protecting Trade Secrets in Litigation as part of Working Group 12. Ben has been named a top 100 super lawyer in Georgia since 2013, and he's also been named one of Georgia's legal elite for many years. Ben obtained his law degree from Emory University School of Law, where he served on the alumni board since 2016 and currently serves as president. And finally, we're very lucky to have the Honorable Stephen D. Grimberg with us today, who's going to provide the judicial perspective on the Defend Trade Secrets Act. Judge Grimberg is a United States District Court Court Judge for the Northern District of Georgia. He was confirmed by the Senate on September 11, 2019, and sworn into office the following week. Before he joined the bench, Judge Grimberg served a distinguished 12-year career with the United States Department of Justice, first as a trial attorney in Washington, D.C., and then as an assistant United States attorney and deputy chief of the Economic Crime Section for the United States Attorney's Office in the Northern District of Georgia. As a federal prosecutor, he investigated and prosecuted a broad array of criminal matters, including healthcare fraud, securities and tax fraud, Ponzi and investment schemes, cybercrime, and public corruption. Judge Grimberg received the very prestigious National Directors Award by the Executive Office of U.S. Attorneys in both 2009 and 2017. Judge Grimberg had joined the U.S. Department of Justice following 7 years in private practice as a litigator, where he represented both plaintiffs and defendants in a diverse litigation practice, including employers and management executives in labor and employment law litigation. Prior to taking the bench, Judge Grimberg served as the general counsel of the Americas for Nardello & Co., a global investigations firm. In that role, he was responsible for advising the firm's executive management and leadership teams on a myriad of legal and compliance matters, as well as supervising the staff of investigators, analysts, and other professionals on complex investigation matters for clients. Judge Grimberg received a Bachelor of Arts degree with distinction from the University of Florida, and like Ben and I, he received his law degree with honors from the Emory University School of Law, where he periodically serves as an adjunct professor, including teaching courses on criminal law, criminal procedure, and courtroom advocacy. We greatly appreciate Judge Grimberg taking time out of his busy schedule to join us for the presentation, and we thank Ben and Jim as well. And with those introductions, I'm going to turn it over to Jim to kick off our presentation.
Thank you very much, Neil. And what we're going to do to talk about where we are today with the Defend Trade Secrets Act is first to talk about how we got there. And there's a fair amount of background I think will inform our discussion. And so I want to jump right into that, but start with learning a little bit about our audience here. So we're going to have just a brief and very simple poll. We put up a question: are you handling a trade secret case now? This will give us a little bit of a understanding of the dynamics of the audience that we now have. So please see the questions up there. We're going to give, this is a pretty straightforward one, so we'll just give a few more seconds before we close it. And there we are. Let's close the poll. And the results, okay, it looks like fully a quarter of the audience is currently engaged in trade secret matters. And the assumption is because the rest of you are here because you have trade secret cases in the past, or you're very interested in, or you expect, as is undoubtedly true, that you will be handling a trade secret case. So let's talk about what it is that we're doing and deal first of all with, let's go to the next slide, try to understand ourselves and the way in which we can take down the poll if that hasn't happened yet. Okay, let's understand the way in which we engage with our clients and with each other about trade secrets. That will help us. And I think traditionally we can see that in the world of registered rights, classical intellectual property that's filed with the government, the lawyers involved in that part of the world have viewed trade secrets traditionally as a mysterious and weird part of the law. It's not based on federal law like the rest of the IP world. It's strange state law that's resolved typically in state court, a place that a lot of these lawyers don't go. It has something to do with employees who leave, but boy, if there's anything we can do to stay away from it, let's do that. And for a long time, a lot of patent lawyers were able to do that because of best mode issues, and they would just tell their clients, just put everything into the patent application and let's go. So that's the way that historically, at least before the American Invents Act, lawyers have viewed trade secrets. But this, in the meantime, with the information age upon us, let's put up the next slide. This is how our clients see trade secrets. For them, it's an issue of assets, data assets that drive their business, that define their competitive advantage, that allow them to increase enterprise value, and that represent a lot of threats to those kinds of assets. And so when they're thinking about trade secrets, to the extent that they do that, and we help them do it, this is the way that they look at it. But it was not always like this. Trade secrets were born in the common law about 200 years ago. So let's take a look at the next slide, which gives us some historical background. Actually, the first trade secrets case was in Massachusetts in 1836, and it involved a chocolate recipe, of all things. As the cases were decided throughout the 19th century, the focus of the courts was on this as an area of tort law. In other words, there was a confidence that was entered into between somebody that got breached somehow, and the law would step in to take care of that, just as a matter of state common law. And what developed was the view that this was an issue of property, but frankly, by the early 20th century, the courts, and with the lead of the Supreme Court in the DuPont versus Maslin case, said basically, look, it doesn't matter if you deny the property, if you talk about how this doesn't really qualify as a trade secret. If you entrusted it to somebody and they breached that trust, that's what matters. So we had this we had this debate that was going on within the courts for a while about whether it was a property-focused law or a relationship-focused law. And I think where we came out with the first restatement was a focus much more on property, because the definition of a trade secret was relatively narrow compared to what we deal with today. You couldn't claim any negative information, the knowledge of what wouldn't work, all the experimental results in a business could not be protected as trade secrets. Anything that was ephemeral, like bids, could not be protected. Information had to be in use in the business in order to qualify. So that was a relatively narrow view. What has happened since then is that with the coming into more of the modern age in the 1960s and 70s, we had the Uniform Trade Secrets Act and the third restatement, the restatement of unfair competition, that took a different and much more expansive view of what trade secrets can be. So today, again, we have a combination that looks both at what is the very broad coverage of the kind of information that can qualify, even though it has limits. Of course, we can't claim employee skill, we can't claim general knowledge, and the law doesn't deal with trifles, so we won't treat as a trade secret something that is readily ascertainable, easily reverse engineerable, that sort of thing. But we're also very mindful that what we're trying to do is protect a confidential relationship. And so that becomes the modern context, or the context for modern law. Let's go to the next slide. So we see that expressed in the first version of the Uniform Trade Secrets Act, which came out in 1979. It was modified in 1985, but essentially pretty much the same thing. Every state has adopted this except for one, New York. And Georgia, as you can see here, adopted the Uniform Act in 1990. Now, the problem with the Uniform Act, which everybody expected, we all thought would lead to the harmonization of laws that up until then were viewed as a patchwork quilt of state decisional law. We thought that would lead to the courts viewing trade secret law as the same throughout the country. And unfortunately, it didn't work that way, in part because most states, including my state, California, fiddled with the language of the law. And so it wasn't enacted in the same way as, for example, the Uniform Commercial Code. And so there were variations in statutes of limitation, damages, other special provisions. And so that by the time that we got into the 2000s, it was increasingly apparent that the experiment of trying to establish harmonization through the Uniform Act was a bust. And so let's go to the next slide. So in the meantime, in 1996, the federal government, following the fall of the Berlin Wall and the crash of the Soviet Union, had enacted the Economic Espionage Act, which became the first, this is a surprise to some, the first federal law directed at trade secret misappropriation. At the time, there was some consideration and discussion about, well, as long as we're doing this, should we also provide for a civil right of action in federal law? But this was being pushed through Congress so fast at the time that it just wasn't time to consider that. And so they left it for another day. And it took 20 years for them to get back to it. And yet by the time that we got to 2013 and 2014, as you see here, versions of what would become the Defend Trade Secrets Act in Congress were being considered, precisely because the general observation by that time had been that the trade secret law that businesses that operated interstate and internationally had to rely on was too unreliable and variable from one state to another, and that businesses needed to have a common law that they could use throughout the United States at their election, and that would be more suited also to international issues as well. So let's go to the next slide. And so what we see here is just a list of the dates that show what happened. In the summer of 2015, I had just returned from Geneva, and that book that Neil mentioned, I had just published, and a bunch of law professors had filed a letter with the Senate and the House indicating their opposition to this draft new federal statute, saying, look, we don't need this. This is federal overreach, and they suggested that it would lead to a new class of very bothersome trade secret trolls, that if this statute, if this bill became law, that we would be encouraging people to run to the courthouse and file a lot of bogus trade secret cases that would be used to hold people up and so forth, just as people were concerned about patent cases. And so at the time, I happened to, I very much disagreed with that. And I put together an opposing article talking about the mythology of the trade secret troll. And all of that led to an invitation from the Senate committee to come and talk to them, to testify as an expert at a hearing in opposition to the law professors, and thereafter to talk to the staff about how to resolve certain issues. The statute almost foundered on the question of inevitable disclosure. And so we had to come up with some language that would address the question of when and how judges would be enabled to issue injunctions that would affect a departing employee and his or her ability to work in a new similar job. That was an issue. One of the biggest issues, however, was the provision for ex parte seizures, because that was a big focus of the professors, who thought that this would lead to abuse in litigation. So we spent a lot of time working on that, basically got through it all, and the act became law in May of 2016. So it applies to any misappropriation that was happening on or after that date. So let's go to the next slide. So where has this gotten us? Has there been increased harmonization? This is very hard to measure, obviously, and yet I can just provide one data point, and perhaps it's anecdotal, but in my job, as it were, keeping up the treatise that I write, I read just about every trade secret opinion that comes out, and I've noticed that there is a very clear trend among federal judges at the trial level to refer to each other's opinions, even though they're in different districts, and to cite each other's reasoning on issues that are decided by the under the Defend Trade Secrets Act, which is very encouraging. And then because the wording of the Defend Trade Secrets Act is intentionally almost identical to the Uniform Trade Secrets Act, we also see a lot of referential opinions in state courts to federal court decisions. And so I think what we're seeing is the beginnings of the kind of harmonization that we had expected to see with the Uniform Trade Secrets Act, but didn't get. And so this, I think, is encouraging. We'll get a little bit more into it later on when we talk specifically about extraterritoriality. But one of the things that we've seen is that the Defend Trade Secrets Act is being used to address some of the things that Congress was concerned about, which is the misappropriation overseas of trade secrets owned by US entities. Cases where the misappropriation happens entirely in another country. And there have been a number of cases brought successfully to jury verdict that are based on that kind of fact situation. And so that's become a major dimension of the law. And then finally, I think it bears mention that the thing that had a lot of the professors exercise, that is the ex parte seizure provisions, have not been widely used. In fact, if you just read the provisions of the law, you can see that it's a very heavy lift to get a genuinely ex parte seizure in place. And layered on top of that were some guidelines that were issued the following year by the Federal Judicial Center that are extremely detailed and very restrictive. And so generally speaking, I think most parties these days will use Rule 65 in a traditional way to get injunctive relief instead of trying to trigger the ex parte seizure provisions. We can talk more about that later. But anyway, that's my introduction to how we got to where we are today. So Ben, let me turn it over to you.
Yeah, thank you, Jim. And just for the audience, I know Neil gave the introduction to Jim already, but I'm sort of honored and humbled to be serving on this panel with Jim. He's been writing, thinking about, litigating, trying cases over trade secrets from the time that I was a little kid. So Jim truly is the dean of the trade secret bar, and I've really enjoyed getting to know him and become friends with him through our work at the AIPLA and the Sedona conference. But Neil, maybe, or Mike, I forget who's controlling the PowerPoint. Maybe we can go to the next slide and talk about some of the differences between the DTSA and the state's laws. And as Jim mentioned, the ex parte seizure provision was probably one of the most controversial provisions in the statute, and there was valid concern, right? If you think about it, it really is based on the ex parte seizure provisions in the Lanham Act. If someone's got a bunch of bootleg T-shirts outside of a concert venue, and a judge issues an ex parte seizure order, and the U.S. Marshal or someone else goes out and seizes those T-shirts, that's something that the courts are used to dealing with, and perhaps the consequences of getting that wrong aren't nearly as great as they are in this context, right? So if I go into Judge Grimberg and I say, Judge Grimberg, I need an ex parte order that is going to allow us to have the U.S. Marshal go to this company and seize their computers because we believe that our former employee is now working over there and took our information. The consequences, the stakes are much, much higher. And so as Jim pointed out, that the courts, fortunately, and probably as many of us expected, have been very judicious in allowing the use of that procedure. But that is one of the biggest differences between the DTSA and the UTSA, the Uniform Trade Secrets Act. Another one that is of some significance is the whistleblower clause. So the DTSA has a clause that basically provides that a individual or anyone else can't be liable for trade secret misappropriation if they're turning information over either to a government authority or to a lawyer for the purpose of some type of whistleblower. They believe something is being done wrong or in violation of the law. And that does not exist in the UTSA. And to my knowledge, Jim, correct me if I'm wrong, it doesn't exist in the in any state law that's adopted the UTSA.
Yeah, I think that's right, Ben, although I suspect that individuals might assert their federal immunity if they were subject to a state claim.
Right, right. So the key there is that in drafting a confidentiality or restrictive covenant agreement for an employee, the DTSA provides that if you don't provide notice to the employee or to the individual signing the agreement that they have that right, then you can lose some of your remedies, such as attorney's fees and exemplary damages. And so that's a critical difference, and one that can really have an impact on practice, particularly on the front end as it relates to drafting agreements that people are going to sign. Now, as Jim just mentioned, I mean, I have not seen, and I'm not aware of a federal court case has determined that it should exercise its discretion to deny exemplary damages or attorney's fees under a state form of the UTSA for a company's failure to provide that disclosure, but that's certainly an issue that could arise at some point. I've certainly had that concern. I've had other lawyers I've talked to have the concern that there could be that issue that could arise even when there's not a DTSA claim that's in play.
Although Ben, one of the practical issues there, and we would ask each other at the time, when was the last time you remember collecting attorney's fees from an individual departing employee defendant? It may be a very small give up, right?
That is very true. Although the hammer of potential attorney's fees and exemplary damages can often drive how that employee is defending the case or how the new company may handle it. So I agree with you that it is rare, but losing out on that remedy is something that you probably don't want to do unless you have a good reason. So I think another key point is that since the DTSA does not preempt state law, we can talk just briefly about, there are significant differences from state to state in the adoption of the UTSA. As Jim mentioned, it's not like the UCC Article 2, Article 9, or most states adopted it exactly as the Uniform Laws Committee intended, but there are pretty significant variations. And so that sort of goes into, on the slide here, we have the question of whether should you include a DTSA claim, a state law claim, or both. And really the only way you can answer that question is in each individual case, making the determination as to what state's law will apply in addition to the DTSA, and determining whether there are components of that law that might be more favorable to you in your particular situation. I'll just provide a few examples. For example, the definition of trade secret is different from state to state. In Alabama, for example, the information must have significant economic value in order to be a trade secret. That qualification doesn't exist under the DTSA, and that's not part of the UTSA. Colorado has a unique definition that does not include the requirement that the information not be generally known and not readily ascertainable. It merely requires that the information be secret or be of value. So if you were contemplating bringing a trade secrets case that is governed by Colorado law, that seems to be a lower bar perhaps than the DTSA or many other states. The definition of misappropriation, even here in Georgia, the Georgia Trade Secrets Act explicitly states that independent development or reverse engineering of a trade secret that is not acquired by improper means is not misappropriation. Now, that's probably generally true in most states anyway, but our statute expressly provides for that. Another key issue in that decision is the statute of limitations. The statute of limitations under the UTSA is 3 years. Under the GTSA, for example, it's 5 years. And so, and Jim, correct me if I'm wrong, I think under the DTSA, it's 3 years as well,
It's
correct?
it's 3 years, right? But that's a good example of the kinds of variations you see.
Right. And so, you know, making that strategic decision, another one has to do with damages and remedies. For example, a reasonable royalty. In Georgia, our statute only allows a reasonable royalty as a measure of damages if neither actual loss nor unjust enrichment are provable. So again, you'd have to look at that on a state-by-state basis to make that determination. You know, just from a strategic standpoint, whether to include both, a lot depends on that. And, you know, we're going to talk more about this maybe a little bit further on, but the other strategic decision is, do you want to be in federal court or not? If you want to be in federal, if you're representing a plaintiff and you want to be in federal court, but you don't have diversity or some other independent basis for federal court jurisdiction, then including a DTSA claim should get you there. Now, I don't know if Judge Grimberger will agree with me on this, but I prefer to be in federal court, and if I have a choice, and a large part that's because I think people and lawyers in particular behave themselves a lot better in federal court.
Based on my docket, I can tell you that there are many people who agree with you.
Yeah. You know, maybe Judge Grimberg should close his ears for a second, but I've often advised my students that you know, given a choice, all of the things being equal, you should be bringing your trade secret case in state court, because most state courts, you know, if you're a plaintiff, you want to be in a jurisdiction where they'll let you try your case, where they're not going to be looking seriously at trying to kick it out on summary judgment and that sort of thing. And so usually in most states, you can get, if you can put it this way, get away with more as a plaintiff than you can in federal court, where the judges are, you have a single assignment system, which doesn't exist in a lot of states. And so the judges are keenly aware that something's occupying their docket that they want to take a look at to make sure that it deserves to be there. So that's a strategic concern. Certainly, if you want to be in state court, you should not file both under both state law and the DTSA, because of course that if you cite the DTSA, then that gives grounds for removal.
Yeah, and you know, I would recognize that sort of whether lawyers behave themselves better in one venue or another, one form or another, is probably not a strong strategic consideration, but all things being equal, from a strategic standpoint, I'd rather be in federal court. But, you know, Jim, to your point, I think you and I talk about this, and I've talked about it with a lot of other lawyers that practice regularly in this area. You know, one thing that is frustrating is, you see a lot of lawyers just throwing in a trade secrets claim when the information that they're really complaining about, you know, no serious trade secrets practitioner would really be willing to allege constitutes a trade secret. And not that I condone that, because I don't, and it really frustrates me when I'm representing a defendant and there's a trade secrets claim on information that, you know, it may be confidential, it may be proprietary business information, but it doesn't even come close to a trade secret. You know, the likelihood is in state court, you may be able to get away with that a little bit more and push the limits. And Jim, as you alluded to, in federal court, you know, most federal judges are going to make you demonstrate, and we're going to talk more in a minute about early identification, but, you know, demonstrate at the pleading stage that what you're alleging constitutes a trade secret, you know, that you can plausibly allege that under Twombly and Iqbal. And that's typically a lower standard in most state courts.
Well, as we were talking about earlier, you know, there was this, there used to be this tension in the law between the property view and the relationship view. In other words, whether it was more about the bad acts in the context of a confidential relationship, or is it about the dimensions of the property right that the law is going to protect? And that tension still plays out in the context of decisions, tactical decisions or strategic decisions about where to file, because a plaintiff may have a case that where the proof of what constitutes a trade secret is weak or challenging, but they've got some really dramatic facts in terms of bad behavior by the defendant. And that's a case where the plaintiff may want to be in a jurisdiction where it's easier to get to trial. And that's just a reality that lawyers have to consider.
I have a question too for Jim and Ben in terms of the decision point of whether to include a DTSA claim and get into federal court. I know that when cases are filed with me that are requesting injunctive relief, I try to take those seriously. We try to get a hearing and a briefing schedule done in short order. Is that part of the analysis as well, Jim, in terms of if you're representing a plaintiff and you truly need to seek emergency relief, the state courts are so overburdened, it would seem that the federal courts would be better equipped to have your matter heard sooner rather than later.
Yes, in that sense, I mean, there's a clearer procedural path in federal courts than in a lot of state courts where it's a bit hit or miss how much of an audience you're really going to get on an injunction. That said, if you have a departing employee case, for the reasons I alluded to earlier, you may want to take a good close look at the special language on injunctions against departing employees that's in the DTSA. We drafted that specifically to address concerns about inevitable disclosure, and it does in some ways restrict what a federal judge can do on that kind of injunction based on the proof that's alleged.
Yeah, and Judge Grimberg, I agree. I think that the issue, a lot depends on the jurisdictions that you have a choice where you would file in state court. For example, here in Georgia, there's just a huge variation from county to county on how the courts deal with TROs and requests for emergency hearings in these cases. Up in Cobb County, for example, you can get a case filed on a Wednesday and have a hearing by Friday, and they have a whole bevy of senior judges. The assigned judges send the cases to the senior judges very easily, and you can get into court quickly. And you typically have a very accomplished bench that understands these cases and these issues. That's not true in every county. And I had one recently where we had no choice but to be in Superior Court. And we filed for a TRO. It involved a non-compete, not trade secrets, but the judge, the earliest hearing he could give us was 4 months after we filed the complaint and the TRO motion. So a lot just depends on the jurisdiction. I will say that I think our current federal bench here in Georgia is great about dealing with these issues quickly, and that wasn't always the case. Judge Forrester, God rest his soul, there was no emergency in any case he had ever seen. I mean, I recall trying to get a TRO hearing with Judge Forrester, and that was impossible. He just had no interest in hearing anything on an emergency basis. But I think that's pretty rare these days, at least in my experience. So if we could go to the next slide, if I can just close the loop maybe on the differences between the DTSA. One I failed to mention that I think is really critical for those of us that practice in Georgia is that the GTSA, when it was adopted, was very specific that information without regard to form is the language that's used in the UTSA. And the change that was made in the GTSA had to do with customers. So in many states, information about customers, even if it's not in the form of a list, can be protected as a trade secret. But that's not the case under the GTSA. Under the GTSA, in order for customer information to be protectable, it has to be in an actual list. Now, the DTSA does not provide for that. It says all forms and types of business information, whether tangible or intangible. So that, again, may be a strategic consideration if you're looking to pursue a trade secrets claim related to customer information that is not contained within a particular list, then in Georgia, then you'd certainly want to proceed under the DTSA and not just under the GTSA. Jim, did you want to talk about available damages, the avoided costs?
Yeah. I mean, this is an interesting one because, as I mentioned before, New York is the only state in the country that hasn't adopted some form of the Uniform Trade Secrets Act. I mean, it's a real example of sort of legislative inertia, I guess. They're still stuck with the common law, and they don't even acknowledge that there's been a new restatement since 1939 when the Restatement of Torts came out. And they keep referring to the Restatement of Torts. It's very awkward in cases where there's research and development material to be protected and the judges have to do some logical spinning and so forth. But in any event, the biggest difference and the reason why the DTSA has become extremely important in New York is because the top appellate court in New York decided 2 years ago that avoided cost damages, which are pled and explored in almost every business-to-business trade secret case, are not available under New York law. There is just not there. That's the Brooks case. And so that restriction of New York law doesn't apply if you're proceeding under the DTSA because it has its own standards for damages. So that's a good example of a place where the DTSA has really helped a lot of cases. And did you want me to go on and comment on the other one?
Sure, yeah. If you,
Yeah, I mean, this goes to what you said earlier, and there is a difference in wording in the sense that both the DTSA and a few state versions of the UTSA, including you mentioned Georgia, California is like that too. Specifically, add the language that reverse engineering or other lawful means of getting to the information will not be considered improper means. In my view, that's just belt and suspenders because it's just re-emphasizing something that's already there. You can't allege misappropriation if someone in fact has arrived at the information independently because they've not used the data. So it's an interesting observation, but I don't think it actually has substantial effect.
Yeah, and just a quick note, if anybody ever needs a resource on the differences among the states in the adoption of the UTSA, our friend Sid Leach at Snell and Wilmer in Phoenix, he's written a tome on it. It's really impressive. It's a 75-page paper where he goes through state by state and the different variations. I'm not sure where it's available, if it's publicly available, but it's a great resource if you ever need. If you're trying to decide between, do I file in Georgia, or do I file in California, or do I file in Illinois? It's a great resource to help with those strategic decisions.
It is available. I know it's posted on the Sedona website.
Okay, great.
So
you want to go to the next slide, maybe? And I guess we've really covered many of the procedural considerations. I think between state and federal court, obviously national service of process is key, and then international discovery that's available. We all are probably pretty familiar with the pleading requirements, Twombly and Iqbal, so that may be a little bit of a steeper climb in federal court. But I think we covered most of the rest of the points there. If you want to get into extraterritoriality, Jim.
Good. Yeah. Why don't we go to the next slide? One of the key drivers for Congress, I mean, Congress didn't get excited about necessarily about smoothing out differences among state laws, but they were concerned and expressed their concern quite directly about China and other foreign countries basically allowing the misappropriation of US-based trade secrets, or actors in those countries engaging in misappropriation that basically we didn't have sufficient tools to address. And so one of the great drivers of getting the DTSA was the idea that it would increase the options that were available to US-based companies that experienced loss of their secrets overseas, and that would basically allow the courts, the federal courts, to reach out and grab subject matter jurisdiction over those kinds of cases. Now, they didn't amend the Constitution. We still have the due process limitations of in personam jurisdiction. But what we ended up with was the decision in several cases, most notably the Motorola versus Hytera case coming out of the Northern District of Illinois 2 years ago, that said, look, there is an existing provision of the Economic Espionage Act, and we should pause here to note that the Defend Trade Secrets Act was an amendment to the Economic Espionage Act, which appears starting at 18 USC section 1831. So if you read through that and you see what was changed with the DTSA, you see what happened was we layered on civil remedies into what had been an exclusively criminal statute. So one of the provisions of the EEA, the Economic Espionage Act, had been extraterritoriality. They expressed this directly. They wanted, Congress at the time that enacted the statute wanted it to apply to any case in which one of the actors was a US citizen or permanent resident, or any act in furtherance of the offense happened within the United States, any act. Now, this language about the offense and so forth led a lot of people, including myself, to wonder, would this apply to the civil provisions that were being interleaved into the Economic Espionage Act? And what the Motorola versus Hytera case said was, yes, it is, despite that reference to offense, it does apply. And so the same jurisdictional reach is available in civil actions. And there was also a more recent clarification that the act in furtherance of the misappropriation doesn't have to be an act of the defendant. It could be someone operating with them or participating in some way. So as long as you could bring it within the ambit overall of the misappropriation act or conspiracy or something like that, then you have the basis for jurisdiction. And so this really has become a fairly powerful tool, along, of course, with the International Trade Commission, for holders of trade secrets in the US that are concerned about the effects of misappropriation that happen elsewhere, and the ability to get real remedies about that misappropriation. And that's in part because in virtually all of the rest of the world, there is nothing like the discovery that we have here. So if you're a trade secret plaintiff trying to figure out what happened, you are best off in the US, because we have the sort of the gold standard procedures for learning what it is that the defendant did. Ben, you have any thoughts, comments on that part? If not, we should probably go on.
Yeah, let's keep moving. I think we're bumping up against our time and want to give Judge Grimberg some time to talk.
Exactly. So here are the cases that I was just referring to. Motorola is the chief one to know. MedCenter simply agrees with Motorola, and MedImpact talks about the kind of activity that will satisfy the action in the US. So be aggressive is the language, or is the lesson from these cases in asserting jurisdiction over international misappropriations. So let's go to the next slide. So here, this issue of identifying your trade secrets is probably the most bothersome for, I think, certainly for courts and also for the litigants in trade secret cases. And it arises because, unlike all the other forms of intellectual property, trade secrets do not come with a government document describing what they are. And so to the extent that there arises some dispute between parties over trade secrets, one of the first things that everybody needs to ask is, what's this case about? What's the subject matter? And the way in which that happens is the story of early identification of trade secrets. Now, a year ago, just over a year ago, the Sedona Conference published a commentary on this, which is very thorough and comprehensive. And so I suggest that anyone who's interested in it, download a copy of that. It's free, and it has a lot of the relevant case law, and it suggests templates for identifying trade secrets and so forth. But how do we get to this? And again, it's a measure of my age. I was involved in that one too. We had a case in California from 1968 called Diodes versus Franzen. And when we were considering the Uniform Trade Secrets Act in 1984, somebody at the state bar had the bright idea that the rule of that case, which was that you are supposed to, as a pleading matter, identify with particularity your trade secrets at the in your complaint without revealing them, but so that everybody knows what the case is about. That we should take that and put some teeth into it by forcing the issue at an early time on pain of losing your right to discovery until you get it right. It was an interesting idea. I helped try to draft it to be a little less onerous than it was, but it went through. And we were living with it for years in a way that created an awful lot of chaos in our trade secret cases in California. Over time, with some appellate decisions that gave guidance to the bar on exactly how to do this, it's been, we've learned how to live with it and how to use it in a way that makes sense. And the general concerns around this are that, look, the court needs to know, in order to manage discovery, what the case is all about. The defendant needs to know in order to prepare a defense. We want to discourage improper trade secret cases by incentivizing plaintiffs to think carefully about their cases to begin with. And we want to avoid situations where the plaintiff just files a case on pure suspicion and then dives into discovery of the defendant to find out information that it then can use and claim as its own trade secret. So those are the stated reasons, policy reasons behind this. And a lot of courts, we've recently had Massachusetts as a state pick up on this and institute a similar law. But a lot of courts throughout the country are basically embracing this approach as a fundamental way to engage in sensible case management in trade secret cases. And so, again, this is one of those areas where we're seeing a lot of emerging uniformity and harmonization happen precisely because these issues are now coming up in federal courts regularly because of the DTSA, and there's an exchange of views and opinions about what's necessary. Now, it's a little bit difficult to extract hard and fast rules from a lot of these cases because the real ultimate description of the trade secret has to be confidential and can't be part of an opinion. But we're getting closer and closer to a set of consensus rules, which we believe we've tried to articulate in the Sedona process. Now, this is a distinct issue, that is identification for identification of trade secrets for case management purposes. It's kind of a distinct issue from what should be in the pleadings, what will satisfy Iqbal and Twombly. There are differences of opinion among courts as to whether or not categories of trade secrets or high-level descriptions suffice, or whether in the complaint you actually have to dive down a little bit deeper. Obviously, you can't reveal the trade secrets, but this tension between what needs to be in the pleading and then what needs to be revealed as part of either very early discovery or case management is a tension that we're going to be continuing to live with, I think.
Yeah, and Jim, this is a real, as you pointed out, it's a real hot issue. We actually here in the Northern District of Georgia have the Derubies case, which gets cited by a lot of other courts around the country on this issue.
Yes.
And I think that decision is, Neil, Jim, you may know, 10, 15 years old at this point. It's been around a while, and it's
yes.
one that,
yes, but it gets cited very, very frequently. It's very, very much respected.
And I think, like you said, the key issue is, as a defendant, you need to understand what it is that you're defending, right? And sometimes a plaintiff will say, well, Judge, I don't know at this point all of the trade secrets that have been stolen. This individual downloaded made a copy of their laptop before they left, and they have all kinds of information. Judge Grimberg, you may not remember this, but we had that case a couple of years ago that he presided, and the other side basically was claiming there were tens of thousands of files on this computer for the employee that my client had hired. And the dispute was, at what point were they going to have to identify what of those tens of thousands of files they really considered to be a trade secret? And the approach that I like to take, and I try to take when I'm drafting the complaint, is to make sure I really know what the actual information is my client is concerned about. A lot of times clients say, well, it's everything, or it's all of our sales information, all of our marketing information, all strategies, all of this, that, or the other. And what I try to do is really get an opportunity to see the information, look at it, and then describe it in the complaint in a way that there's no question about what it is that I'm referring to. I have a client that they do a really interesting commercial space in the commercial space industry. And they had developed a satellite that could be used for very, very small satellite that could be used for all kinds of different purposes. And they had some folks leave and take some of the technology with them. And they had, very clear calculations they had made, spreadsheets. There were things that really were a trade secret and that were easy you could look at it. And obviously we didn't have to put all that in the complaint. We could just describe exactly what was in those, not what the conclusions were, but what those documents were and what they contained and why that was secret. And so I try very hard when I'm drafting the complaint to provide as much specificity as possible to avoid this issue. And sometimes, defendants and particularly defendants who have lawyers that practice in this area regularly will just file these motions sort of as a knee-jerk reaction to any trade secrets complaint. But I think most judges will see through that if you do describe with sufficient particularity in your complaint what the trade secret is that you're concerned about, rather than just throwing in these broad generalizations in the kitchen sink approach, saying that everything this person had access to and everything that they are believed to have taken constitutes a trade secret.
Yeah, if we could just go to the last slide here, and then it'll bring this all the way through by looking at some of the most recent cases on this point that reveal a little bit of the tension that's going on. The Cisco case, is fairly extreme. when it comes to pleading, the court there wanted, with respect to each category of trade secret information that was being identified in the complaint, for the plaintiff also to separately plead facts demonstrating the value of that trade secret. That's how that's the level of detail that some courts are looking for in complaints. On the other hand, we have these two appellate decisions, one from the Ninth Circuit and one from the Third Circuit, that have come out in the last year that basically tell us, hey, everybody, let's not forget that the discovery process exists to help us understand what's going on, and artificial requirements for early identification and so forth, and they can be helpful, but sometimes the process gets misused. And in Teleclear, the plaintiff had made a couple of attempts in its complaint to identify the secrets that were at issue. And on the first day that discovery would have opened, the defendant filed a motion for summary judgment, and for reasons I can't figure out, the trial court granted it. And the Ninth Circuit said, no, we can't do that. We need to let the discovery process move forward, and you'll get more information about the trade secret that way. And the Oakwood Labs case similarly points this out. So this is kind of a leavening of the concern that folks address at the time of the complaint. Let's remember that we do have discovery available. So there we are. I think at this point, Ben, we'd be very interested to invite the judge to help us understand his perspective about the special dimensions and aspects of these cases.
Absolutely.
Sure. Thank you. And as I mentioned to the other panelists as we were preparing for this talk, those who you have already heard from are the true subject matter experts in this area, and I'm happy to offer my perspective from my experience on the bench, as well as from my previous experience. But those are the true experts, and I'm honored to be part of this panel with them. As you heard from the bio that Neil gave at the beginning, I've only been on the bench for 2 years, so my experience from this perspective is limited. But to show you how prolific these issues come up, it has really touched every aspect of my career personally. I was in private practice for a number of years, primarily in the labor and employment area, and obviously trade secret issues arose often during my time then. When I joined the Justice Department, I was a prosecutor. Trade secret issues arose all the time, both from a prosecution standpoint in terms of prosecuting cases, criminal cases, where there had been a misappropriation of trade secrets, and there were oftentimes parallel civil cases at the time. But also in the cyber area, I did quite a bit of cyber cases where obviously the theft of trade secrets were oftentimes at issue from the victims of those cyber attacks. And then just prior to joining the bench, as you heard, I was the general counsel of an investigations firm where I saw the perspective of oftentimes of the clients that you all have on how best to protect and preserve the trade secrets that they hold. But let me offer just a few thoughts here, and then we can open it up to questions. A lot of what Jim and Ben have said has been music to my ears, because it was exactly the thoughts that I wanted to emphasize as well. First, with respect to defining what the case is about and defining what the trade secrets at issue are, to me is key. Being specific at the pleading stage is really helpful to the court, certainly to the litigants and to the court in terms of trying to resolve these issues. I won't necessarily opine today about whether sort of a categorical approach to defining the trade secret is sufficient in federal court, because I think it will depend on the case and the industry. But certainly, once you are asking the court to make a determination, whether it's at the injunctive relief stage or at a dispositive motion stage, being detailed on what it is that you believe constitutes a trade secret is key. And I think oftentimes what I have seen is that litigants will sort of presume the trade secret status and go straight to misappropriation, or at least conflate those issues. And that is an area that I think is worth paying attention to. Same goes for that misappropriation prong. Oftentimes, the claim of misappropriation is again being conflated with the trade secret issue. If you have identified trade secret with specificity, it doesn't necessarily translate into a misappropriation simply because of the temporal proximity of the issue of the trade secret being available on a laptop, for example. Oftentimes I've seen the allegations of misappropriation are speculative, at least at that injunctive relief stage. And I understand, obviously, it's a chicken and egg issue, because you need to take the discovery that you want to take in order to be able to prove up the misappropriation. But there are other avenues to doing that, depending on your client's resources. I think you should consider the use of outside investigators to be able to prove the misappropriation, or at least make a showing that is beyond speculative at that injunctive relief stage. I personally love these cases. I really enjoy them in the experience that I've had. The bar is terrific. And when we do have injunctive relief hearings, whether as a ex parte TRO or a preliminary injunction, from my perspective, they're fun, because they're sort of like a case in a box, where you are able to hear the evidence and decide the case all in a matter of days, which you don't get to do oftentimes in other types of cases. So I enjoy them personally. But the advice that I would offer from what I have observed so far is, if you're going to ask for extraordinary relief, then you should be extraordinarily prepared to do so. And the quality of the representation at that injunctive relief stage has been mixed, in my view. Present company excluded from the panelists on this esteemed presentation, but be prepared. If you are asking for the court to do something at that early stage of a case, and asking the court to step in, because irreparable harm is going to be committed on your client, so much so that money damages will not suffice, show the proof for that, because that is the perspective of the judge. And I know I'm happy to hear that my court and my colleagues on the court are receptive to having these hearings. But remember, we are hearing all kinds of cases in our court every day, including a healthy docket of criminal cases. And so for a civil litigant to come in and say, this is an emergency, when we have just had 3 criminal cases heard with a defendant who is being detained, it gives us a different perspective on what constitutes a true emergency. So be prepared to answer that question, at least explicitly or implicitly, as to why this deserves the attention of the court and the resources of the court, because sometimes these hearings can take up a considerable amount of time, of court time and staff time to resolve. So be prepared to make a showing as to why that is, and be prepared to prove your motion.
Judge Grimberg, I had a case with Judge Duffy once where I was representing a defendant and we got into court for the TRO hearing. And he said to the plaintiff's lawyer, he said, "I'm dealing with people's liberties back here. This better be good." And so
Right.
it was a good way for me to start the hearing, but not for them.
Exactly. And it gives you a good perspective for sure. And it's something that you can relay to your client, because I know that you have the client pressure of, as you said, Ben, everything in this laptop is a trade secret. And I think you can use the judge as your boogeyman to say, well, this is, we're going to need to be more detailed and more specific as to what is the true emergency here. Having said that, I think you do need to balance that, because while you want to be prepared for asking for that extraordinary relief and have all your ducks in order before you come to the court and ask for that relief, I think you do have to balance that with your request becoming too stale. I've also had the flip side of the issue where a litigant has waited for a matter of months or even years before coming to court and asking for injunctive relief. And when asked about the delay, the response has been, well, I wanted to make sure I had all the evidence, and from a Rule 11 perspective, wanted to make sure that I was coming to the court with a colorable claim. But at the same time, if you have waited that long before asking for injunctive relief, it's hard to answer the question as to why the damage is irreparable, why that harm is irreparable, and why at that point we just can't let the litigation play out and compensate the victim of the offense or the litigant in a way that with money damages at that stage of the case. Let me just address also sealing issues briefly in terms of sealing pleadings because of the disclosure of confidential information, trade secret information. Certainly in federal court, you have a mechanism for doing that, and you should take advantage of that. Make sure that you are complying with the court's local rules and the standing order of that particular judge on the process for doing that, and take advantage of that in order to provide the specificity that you feel is needed, so that the court at least has full information and can make an informed decision. But keep in mind that from a judge's perspective, sealing motions are ones that we have to be particularly vigilant of, because unlike almost every other motion and request that's made of the court, where you can rely on the adversarial system to protect the various interests that are at play, when it comes to sealing, my feeling is, and I think most of my colleagues are as well, that there's no one else minding the store, right? The litigants may not necessarily care about a pleading or a piece of information being sealed, as long as they know what it is. And they don't necessarily have the same interest of transparency and public disclosure that we have as a court. And so my feeling is that we need to, me and my staff need to make sure that there's not over sealing taking place. So when you do file information under seal, make sure that you're only sealing or redacting the information that truly needs to be sealed, and not just wholesale filing an entire document under seal, or sort of over redacting what needs to be done. What I have done and what I've asked my law clerks to do when there is a sealing motion is to take a look at the unredacted or sealed document, and if it has been sort of overdone, to provide at least a few examples of that back to counsel so that it can be sort of revised in that fashion. Finally, last thing I'd like to leave you with in terms of my comments, and then, like I said, happy to take questions, is that oftentimes these cases of trade secret misappropriation are the types of cases that we sort of colloquially refer to as business divorce cases, where you have a former executive or a former employee who has left and starting a competing business. And so emotions are running high on both sides. And just like divorce lawyers and family lawyers sometimes need to act like therapists for their clients, I would encourage you to do the same in those situations and make sure that you are demonstrating your professional commitment to try to resolve the case in a way that is most economical and efficient for your client and for the court, and avoiding situations where the emotions are taking over for a principled approach as to how to resolve a case in a way that doesn't break the bank and does so that is, in a way that's out of proportion to what's truly at stake.
Judge, that last comment is so apt for these kinds of cases, and just reminds me of an article that I wrote a couple of years ago. It's on my website. That was titled "Everything I Needed to Learn About Trade Secret Cases I Learned in Divorce Court," because of that emotional content. It's, yeah, very good point.
Well, thanks to our three panelists for their excellent presentations and thoughts. We're going to now take our last few minutes to do some question and answer. And there's a few good questions in the chat that I'm going to pose to the panelists. But before I do, I had a question related to injunctions in trade secrets cases. Ben and Jim talked a lot about identifying and the specificity around identifying trade secrets in pleadings and then during the discovery process. What about in injunctions in trade secrets cases? Maybe Judge Grimberg and Ben and Jim could weigh in on how we deal with the dichotomy between a broad prohibition on don't use the trade secrets that probably doesn't comply with the specificity required by Rule 65, and avoiding we're not going to put the actual trade secrets in the injunction, striking that balance and giving the plaintiff the appropriate protection if the court's found that such protection is warranted.
Well, if I can speak first to that, generally speaking, the way that you've described them there, Neil, we look at the pleading as one level of specificity. We look at informing discovery and management of the case as another level of specificity that's perhaps higher, more demanding. When you get to an injunction, it's you're at perhaps the highest level of specificity that's required, because someone is going to be directed to conform their behavior to that on pain of possibly going to jail. So we need to be as specific as we can. And so judges are very properly focused on that at the Rule 65 stage, and they figure out ways through either code words or references to documents that the defendant has in their possession to identify the kinds of things that they are being directed not to use. But it's one of the great challenges that a lot of plaintiffs' lawyers, when they go in, don't really think through, that they have to get an injunction that, as you say, is a lot more specific than don't use the trade secrets, because you know what they are.
Yeah, and Jim, to add to that, I'm amazed though at how many times, probably more in state court certainly than federal court, judges will just sign an order saying the defendant shall not use or disclose any of the plaintiff's confidential information or trade secrets, and then that's it, like nothing more. And that's obviously not sufficient, but it happens frequently.
And I would just add, again, further to the point I made before, if you're asking for injunctive relief, do not leave anything off the table. I mean, at that point, you need to bring to bear all the information and as detailed of the information as you have. And if there are concerns about disclosure in terms of the transcript and the public record, then there's ways to resolve that. Just as you would with a sealed filing, you can ask the judge under the same standard to seal that portion of the transcript or seal those particular exhibits. And personally, I'm happy to do that if you've made that showing. The entire hearing is not going to be sealed. We're not going to shut the courtroom. But if there is something in particular that needs to be kept confidential, which is at the heart of the matter that's being resolved, then certainly you can make those requests. But concerns about confidentiality should not prevent you from presenting the evidence that you need to present.
Thanks, everybody. We had a question from the whistleblower portion of the presentation. That's a good one that I hadn't thought about. The question from Patrick is the loss of attorney's fees and the other remedies like exemplary damages for failure to give notice of the whistleblower immunity. Is that only applicable in an action against a former employee? So if you've got a claim where the new employer and the employee have been named as joint defendant, is the new employer still exposed to the attorney's fees and exemplary damages?
If I could jump in on that too, I think it's a great question. It hasn't specifically come up, but I think the answer to that is no, should be no. If you look at section 1833 of the statute, the subsection on non-compliance, it's titled that way. And what it says is that if you don't comply with the notice requirement, then the employer may not be awarded exemplary damages or attorney's fees in an action against an employee to whom notice was not provided. So in that action, if the new employer is also being sued, certainly I think you could just apply the language of the statute as written. And even if he was sued separately, I think the public policy argument would be strong. So yeah.
And Neil, there was a related question about whether the provision applies for a patent infringement, if the information is used for patent infringement to identify that there's an infringement. And I was trying to look at it while we've been talking. It says an individual should not be held criminally or civilly liable under any federal or state trade secret law for the disclosure of a trade secret that is made in confidence. One of the things is to an attorney solely for the purpose of reporting or investigating a suspected violation of law. Jim, I don't know if you know, but I mean, it would seem to me, I guess a patent infringement is a violation of law unless you disagree.
Well, that's another one I haven't seen a court specifically address, but I think what they're after here is a pathway to law enforcement. That this is meant, it was originally designed to address disclosures to the U.S. attorney or similar prosecutorial authorities, but it was also recognized that in order to do that as a practical matter, you needed to be able to share it with your own lawyer as well. So what you're trying to do is provide information to your lawyer so that ultimately can happen. I mean, so far as I know, when somebody is engaged in patent litigation and they're trying to inform their lawyer of all of the relevant information, I can't remember a case in which a lawyer was sued for receiving confidential information from their client that they needed in order to defend themselves in a patent case.
A couple other questions I'm going to try to get to quickly. I know we're almost out of time. This may be a quick one, but how do damages play out when you allege both a Defend Trade Secrets Act and state law claim in the same case, given that the elements are similar? Are the damages going to be be cumulative. Ben or Jim, what do y'all want to weigh in on that?
Ben, you want me to do it?
Yeah, go ahead, Jim.
Okay, well, if the measure of damages is the same, then there's no issue, and you'll just prepare the jury instructions to reflect the standard that appears in both statutes. If it's different enough to be meaningful, then you have an election of remedies issue, and you just need to decide which one you're going to be doing.
Thanks, Jim. I'm going to ask a quick question for Judge Grimberg before we wrap up. Judge, have you had any experience with ex parte seizure requests under the Defend Trade Secrets Act, or generally kind of what's your view on ex parte TRO requests in either non-compete or trade secrets cases? Do you prefer to wait till the other side is served and has appeared, or will you entertain ex parte relief if there's really extraordinary circumstances?
Yeah, no, I have not had any ex parte seizure requests under the DTSA. I have had several under the Lanham Act, and which, has been pointed out, are oftentimes, as he said exactly, the T-shirts outside the concert venues and things of that sort. But no, not under the DTSA. I personally will entertain ex parte TRO requests. I leave it to the litigant to determine whether it warrants that extraordinary relief. The first question that will often, when we have the TRO motion filed in a case assigned to me, the first question that's going to come back to you from my courtroom deputy is going to be that exact question. Do you in fact wish for this to be an ex parte TRO, or what do you really mean a preliminary injunction, and do you wish to wait until the other side has been served so that we can have a preliminary injunction hearing? Because oftentimes litigants will call it a TRO, but in fact what they really want is a preliminary injunction hearing. So we will make that clarification request at the outset. But if what you want is a TRO for 14 days, then I will hear that. We'll get a hearing scheduled in short order, and I'll hear that motion. I'm not sure how my colleagues feel about it, so that's just individual to me.
Thank you, Judge. Well, Jim, Ben, Judge Grimberg, we really appreciate the three of y'all spending the time with us today, especially Judge Grimberg with your busy schedule. Everybody's presentation was excellent. We really appreciate the excellent attendance and the great questions from the audience. I put my contact information in the chat message if you're interested in joining our committee and participating and helping us plan more events like this one. We welcome the participation, and we're eager to have more folks. Thanks everybody again, and appreciate everybody's time today.
Thank you.
Thank you. Bye, everybody.
This concludes today's webinar. Thank you for joining and have a great afternoon.